Harani Law Circle Manavargal and Vanakkam. I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 16 of our target to complete 50,000 multiple choice questions in law. If you haven't seen our previous 15 parts, I request you to visit our channel's playlist or check out for the links in the description box. These 50,000 multiple choice questions will help you crack any legal examination which is conducted in your state or on the national level, be it the civil judge exam, special legal officer exam, judicial services exam, or even the district judge examination. You will have the confidence to put your 100% in the performance. These 50,000 questions are divided into 1,000 parts to make it easy and comfortable for you in your preparation. Our team has also planned for a mains-based descriptive question and answer series where I'll be covering around 1,000 mains-based descriptive questions along with answers and explanations. It will be very helpful for you. So a comprehensive coverage of prelims, mains, and interview sessions in our channel will help you crack any judge examination. The only favor that I request from you students, I want you all to share this session or our playlist to your friends, juniors, if you are a professor who is watching this session, to your students as well, who are not able to afford for a proper coaching. In that way, it will be very, very helpful for them as well. This session, we'll be covering the Code of Criminal Procedure. So all 50 questions in this session will be from the same code. Let's move to the first question. So the questions will be in English and the answer to each of the questions are given to you in bold letters, and the explanation will be as follows in the next slide. What is the minimum population required for an area to be declared a metropolitan area under Indian law? So if the population is 1 million, then it can be declared a metropolitan area by the state government. So let's read the explanation. According to Section 8, Clause E of the Code of Criminal Procedure 1973, a metropolitan area means the area declared or deemed to be declared under Section 8 to be a metropolitan area. As per Section 8, subsection 1 of CrPC, the state government may, by notification, declare that, as from such date as may be specified in the notification, any area in the state comprising a city or a town whose population exceeds 1 million shall be a metropolitan area for the purposes of this code. Moving to the next question. Can the state government extend, reduce, or alter the limits of a metropolitan area? So the answer is yes, it can. It can extend, reduce, or alter the limits of the metropolitan area. Section 8, subsection 2 of the Code of Criminal Procedure states, the state government may, by notification, extend, reduce, or alter the limits of a metropolitan area, but the population of such area shall not be reduced to less than 1 million. So the key points which you need to remember here is, the state government has the exclusive power to modify the boundaries of a metropolitan area. However, after alteration, the population must remain above 1 million, that is 10 lakhs. This ensures that the metropolitan character of the area is preserved. Moving to the third question. Who can establish a court of session for every sessions division? The High Court, the state government, the central government, none of them. So a state government can establish a court of sessions for every sessions division. According to Section 9, subsection 1 of the Code of Criminal Procedure, the state government shall establish a court of sessions for every sessions division. However, while the state government establishes the court, the appointment of the judges is done by the High Court under Section 9, subsection 2 of Criminal Procedure Code. So the major points that you need to remember is, the state government can establish the court of sessions for every sessions division, and the appointment of that judge is done by the High Court. Next one. To whom should all assistant sessions judges be subordinate? So the assistant sessions judges are subordinate to which judge? So the correct answer is sessions judge. According to Section 9, subsection 4 of the Code of Criminal Procedure, all assistant sessions judges shall be subordinate to the sessions judge in whose court they exercise jurisdiction. The key points that you need to consider is, the sessions judge is the head of the sessions division. Additional sessions judges and assistant sessions judges function under the overall administrative and judicial control of the sessions judge. The sessions judge has the power to distribute businesses among them as per section 194 of Criminal Procedural Code. Next one. Can an assistant sessions judge dispose the urgent applications? He cannot. He can dispose if he is authorized by the sessions judge. In the event of his absence or inability to act, he can dispose bail applications other than murder cases, none of the above. So an assistant sessions judge can dispose of urgent applications if he is authorized by the sessions judge in the event when the sessions judge is absent or he is unable to perform such acts. So according to section 10 subsection 3 of the Code of Criminal Procedure, the assistant sessions judge shall have no power to entertain or dispose of any applications or proceedings that the sessions judge is empowered to deal with. So there is an exception clause where when the sessions judge is absent or otherwise unable to act and the sessions judge is specially authorized by the sessions judge to dispose of such urgent applications, then the assistant sessions judge can dispose of such applications. Next one. Can a sessions judge make provisions for the disposal of any application? Yes, but only in favor of additional sessions judge, only in favor of assistant sessions judge, only in favor of chief judicial magistrate, in favor of additional sessions judge or assistant sessions judge or chief judicial magistrate. So the correct answer is in favor of additional sessions judge or assistant sessions judge or chief judicial magistrate. So a sessions judge can make provision for the disposal of any applications to them. So section 10 subsection 3 of the Code of Criminal Procedure says the sessions judge may make provisions for the disposal of any urgent application by an additional sessions judge or an assistant sessions judge or a chief judicial magistrate in the event of his own absence or inability to act. Next one. Where can courts of judicial magistrates be established? So it can be established by the state government can establish at the specified place after consultation with the High Court. So the state government should consult the High Court before establishing a court of judicial magistrate. According to section 11 subsection 1 of the Code of Criminal Procedure, in every district not being a metropolitan area, the state government may, after consultation with the High Court, establish as many courts of judicial magistrates of the first class and of second class at such places as it thinks fit. So the High Court has the power to tell the state government it can establish at such places as it may deem fit. Okay, next one. Who has the power to confer the powers of the judicial magistrate of the first class on a judge in a civil court? So the powers which the judicial magistrate of first class can be conferred upon a judge of a civil court. Basically, we all know that the judicial magistrate is a person who deals with criminal matters. So these powers can be conferred upon a judge of a civil court. Who can confer such powers? The state government, after consultation with the High Court, may confer powers which the judicial magistrate of first class has on a judge in a civil court. So section 13 subsection 1 of the Code of Criminal Procedure states that the state government may, after consultation with the High Court, invest in any person who holds or has held any post under the government and who is a judge of a civil court with the powers of a judicial magistrate of the first class or of the second class to be exercised in such local area as may be specified in the order. So the key points are with respect to the same section. Next question. Who can be appointed as a chief judicial magistrate? Additional sessions judge, assistant sessions judge, a judicial magistrate of first class, none of the above. The correct answer is judicial magistrate of first class can be appointed as a chief judicial magistrate. Section 12 subsection 1 of the Code of Criminal Procedure states in every district not being a metropolitan area. Because in metropolitan area, the chief judicial magistrate is called as chief metropolitan magistrate, right? So in every district not being a metropolitan area, the High Court shall appoint a judicial magistrate of first class to be the chief judicial magistrate. Next, to whom should the chief judicial magistrate be subordinate? Assistant sessions judge, additional sessions judge, none of the above. So the chief judicial magistrate is subordinate to sessions judge. Next, section 12, subsection 2 of the Code of Criminal Procedure states that the chief judicial magistrate shall be subordinate to the sessions judge. The sessions judge is the head of the sessions division. All the judicial magistrates, including the chief judicial magistrate, function under the control and supervision of the sessions judge. The sessions judge has both administrative and judicial control over the magistrates. The CJM, Chief Judicial Magistrate, also supervises other judicial magistrates of first class and second class within the district. Next one. To whom should the judicial magistrate of first class be subordinate? Special Judicial Magistrate, Chief Judicial Magistrate, Sessions Judge, DNC. So the judicial magistrate of first class are subordinate to both Chief Judicial Magistrate and Sessions Judge. Option D is the correct answer. According to section 15, subsection 2 of the Code of Criminal Procedure, every judicial magistrate other than the Chief Judicial Magistrate shall be subordinate to the Chief Judicial Magistrate, and every Chief Judicial Magistrate shall be subordinate to the Sessions Judge. So the key points that you need to consider for the examination perspective is judicial magistrates of first class are subordinate to the Chief Judicial Magistrates, and the Chief Judicial Magistrates in turn is subordinate to the Sessions Judge. Therefore, the Judicial Magistrate of first class is indirectly under the supervision and control of the Sessions Judge as well. The Sessions Judge exercises general control. General control means administrative and judicial control over all the magistrates in the Sessions Division. It may be the Judicial Magistrate of first class, it may be the Judicial Magistrate of second class, or the Chief Judicial Magistrate himself. Okay, I hope now you understand. Next one. Who is authorized to appoint executive magistrates? So the appointing authority is the state government. The state government may appoint the judicial executive magistrate. Sorry. According to section 20, subsection 1 of the Code of Criminal Procedure, in every district and in every metropolitan area, the state government may appoint executive magistrates and shall appoint one of them to be a district magistrate. So there is no distinction between a metropolitan area and other districts here. In case of executive magistrates, the state government may appoint. It is not a compulsory mandatory provision under section 20 subsection 1. The state government may means it may not also. The state government may appoint executive magistrates and shall appoint one of them to be the district magistrates. So the key points that you need to consider for the exam is the state government has the exclusive power to appoint executive magistrates. These officers are part of the executive branch and they are not part of the judiciary. The district magistrate is the head of all executive magistrates in the district. The executive magistrate performs functions related to law and order, public safety, and preventive actions under CrPC. Okay, next one. Who has the powers to appoint a public prosecutor in the High Court? The state government, the High Court, the central government or the state government by the consultation with the High Court. So the central government or the state government, after consulting the High Court, may appoint a public prosecutor to the High Court. So under section 24 subsection 1 of the Code of Criminal Procedure, it states that for every High Court, the central government or the state government, so both, okay, for every High Court, the central government or the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutor. So for every high court, the central government or state government should, the word shall gives you the mandatory rule that it shall appoint, and the second line says it may also appoint one or more additional public prosecutors. Additional public prosecutors are not mandatory in nature. The state or central government may appoint. It may not also. Okay. But public prosecutor is mandatory after consultation with the High Court. So on appointing any of these positions, the public prosecutor or the additional public prosecutor, it has to consult with the High Court. Next one. Who has the power to prepare a panel of names of persons to be appointed as public prosecutor for the district? So when the central government or the state government, after consultation with the high courts, appoint a public prosecutor, right? So who can prepare the panel of names and recommend it to the central government or state government? The district magistrate after consulting the sessions judge. So the district magistrate is the head of the executive magistrate and all the judges who are below the sessions judge. So the district magistrate, after consulting with the sessions judge, who is the head of the chief judicial magistrate, who has the controls of chief judicial magistrate of first class and second class, after consulting with him, may prepare a panel of names and send it to the central government or state government for the consultation with the high court, and then a public prosecutor shall be appointed for that high court, or an assistant public prosecutor may be appointed for the high court. Do you get the point? So I'm just linking points together which we saw previously. So the previous questions are being linked together to form an entire paragraph that you won't forget at all during this entire period of study, because that will help you remember the options and the questions. Next one. Who cannot be appointed as a public prosecutor for the district? Whose name does not appear in the panel of names prepared by the district magistrate, whose names do not appear in the panel of names prepared by the sessions judge, whose names do not appear in the panel of names prepared by the state government, none of the above. So as we saw in the previous question, the district magistrate prepares the panel of names to be appointed as a public prosecutor with the consultation of the sessions judge. Clear? Okay. Next. So according to section 24, subsection 5 of the Code of Criminal Procedure, a person shall not be eligible to be appointed as a public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared under section 4, subsection 4 of the section 24, where it clearly states that the district magistrate in consultation with the sessions judge prepares the panel of names. So the sessions judge does not prepare the panel of names, or not the state government. It is the district magistrate who prepares it and sends it for the consultation to the sessions judge. On the consultation with the sessions judge, the district magistrate prepares it and sends it to the central government or state government, and the central government or the state government, with the consultation of the high court, appoints the public prosecutor or may appoint the additional public prosecutor. So who is eligible to be appointed as a public prosecutor or additional public prosecutor? So the correct answer is who has practiced as an advocate for not less than 7 years. So the district magistrate who prepares the panel of advocates who are eligible for becoming a public prosecutor, they should have practiced as an advocate for not less than 7 years. So they have to practice for a period of 7 years. Only then their names can be included by the district magistrate after consultation with the sessions judge to the central government or state government. So section 24, subsection 7 of the Code of Criminal Procedure states that a person shall not be eligible to be appointed as a public prosecutor or additional public prosecutor unless he has been in practice as an advocate for not less than 7 years. So these years are very important. Next one. Who can be appointed as a special public prosecutor? Any person who has been in practice as an advocate for not less than 10 years. So public prosecutor and additional public prosecutors, the practice period is 7 years, not less than 7 years. But for special public prosecutors, the practice period is 10 years. 3 years more need to be there for special public prosecutors. Don't confuse with the options now. Next one. So section 24, subsection 8 of the code states that the central government or the state government may appoint for the purposes of any case or class of cases a person who has been in practice as an advocate for not less than 10 years as a special public prosecutor. So the appointment can be made by the central government or the state government. So the appointment is case specific or for a class of cases. Example, CBI cases or special crime cases. Next one. Who is empowered to be appointed as the assistant public prosecutor? The High Court, the state government, police recruitment board, none of them. So the answer is the state government. As per section 24, subsection 3 of the Code of Criminal Procedure, for every district, the state government shall appoint a public prosecutor and may also appoint one or more additional public prosecutors or assistant public prosecutors. So the state government shall in the sense it should, and may in the sense it may or may not. Okay. Next. Is a police officer eligible to be appointed as an assistant public prosecutor? Yes, no, when no assistant public prosecutor is available, none of them. So a police officer can be appointed as an assistant public prosecutor when there is no assistant public prosecutor who is available. You cannot blindly say that he cannot be appointed. He can be appointed when no assistant public prosecutor is available. So where do we take this legal provision from is section 24 subsection 7 with section 25 subsection 3 of Criminal Procedural Code. Police officers are not generally eligible to be an assistant public prosecutors, but there is an exception by reading these two provisions together, where if no regular assistant public prosecutor is available, the district magistrate may appoint a police officer as assistant public prosecutor. Conditions for such appointment are the officer has not participated in the investigation of the offence, or the officer holds a rank not below that of the inspector. He should be at least in the rank of an inspector, or he should have not participated in the investigation. Only then he can be appointed as an assistant public prosecutor, and the person who appoints him as an assistant public prosecutor is a district magistrate. But as a general rule, if the statement says in general police officers are not eligible to be an assistant public prosecutors, then the statement is correct. In case of exceptions, then the statement is wrong. Which police officer cannot be appointed as an assistant public prosecutor? Now we already saw this in the explanation. If he has been taken part in the investigation of the offence with respect to the accused who is prosecuted, or if he is below the rank of an inspector, he cannot be appointed as an assistant public prosecutor by the district magistrate. Section 25 of the Code of Criminal Procedure under subsection 2 is a saving clause, where it says that saving clause means it's an exception. It says that save as otherwise provided in subsection 3, no police officer shall be eligible to be appointed as an assistant public prosecutor where no assistant public prosecutors are available for the purposes of any particular case. The district magistrate may appoint any other person to be the assistant public prosecutor in charge of that case, provided that the police officer shall not be so appointed if he has taken part in any investigation into the offence with respect to which the accused is being prosecuted, or if he is below the rank of the inspector. So the previous three questions are combined together and the explanation is given. So that we are repeating the questions in different forms because to make you to remember the concept, and you won't forget in future. That is the main point here. We are not like trying to repeat the questions. We are trying to make you understand CrPC completely, section by section, and I'm not trying to skip questions. So that is the reason, because we have ample time to prepare. It is not that you prepare today and go write your exam tomorrow. You prepare day by day. Every video you see, you prepare, and at one point of time, within 6 months or 1 year, you will be writing the exam. So you should be prepared at that time. For that purpose, we need to get the conceptual understanding to mark the answers correctly in the exam hall. 21. Can a private person conduct investigation? We already saw this question in the previous sessions also. He can conduct investigation if he is authorized by a magistrate. So section 156 subsection 1 of Criminal Procedural Code provides that investigation of cognizable offences is the responsibility of the police. It states that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case, but there is an exception under section 202 subsection 1 of CrPC, where it states that the magistrate may, for the purpose of deciding whether or not there is sufficient ground for proceeding it, direct an investigation to be made by a police officer or by such other person as he thinks fit. Okay. So any other person can also conduct such investigations. Next one. Offences under the Indian Penal Code may be tried by High Court, the Court of Sessions, any other court by which such offence is shown to be in the first schedule to be triable, all the above. So offences under the Indian Penal Code may be tried by the High Court, the Court of Sessions, or any other court by which such offence is shown in the first schedule to be triable. It can be a bailable offence or a non-bailable offence. Next one. When can a judicial magistrate of first class try an offence for which imprisonment for life is prescribed? So the correct answer is it can, if such offence is shown in the first schedule to be triable by such court. In case if such offences is shown to be in the first schedule to be triable by the judicial magistrate of first class to try an offence where the punishment for the offence is imprisonment for life, then the judicial magistrate of first class can try that offence. If it is not shown in the first schedule of Criminal Procedural Code that the offence can be triable by the judicial magistrate of first class, then such offences which involve the punishment of imprisonment for life cannot be tried by the judicial magistrate of first class. I hope you understand the links. As per section 28 subsection 1 of the Code of Criminal Procedure, a judicial magistrate of first class may try any offence for which imprisonment for life is prescribed if such offence is shown in the first schedule to be triable by a judicial magistrate of first class. Normally, offences punishable with imprisonment for life are triable by the Sessions Court, where the exception has been given under section 28 subsection 1. If the first schedule specifically mentions that the offence is triable by a judicial magistrate of first class, then the magistrate can try it. Next one. Which court has to confirm a sentence of death passed by a court of sessions? So, a court of sessions pronounces a judgment stating that the accused is a convict and he punishes him with a capital punishment of death sentence. Who needs to confirm the death sentence? It is not executed directly after the Court of Sessions pronounces the judgment. It is only after when the High Court confirms the sentence of death, the execution of death sentence can be made. So the High Court should confirm. As per section 366 of the Code of Criminal Procedure, no Court of Sessions shall pass a sentence of death unless the High Court has confirmed the sentence. The key points that you need to remember is the Sessions Court may award death sentence only after trial, and the High Court must confirm the sentence for it to take effect, and the Supreme Court becomes involved only on appeal or curative review cases, not an initial confirmation. So the High Court can confirm death sentence. So we are in the mid part of our session 25. What fine can be imposed by a sessions judge or additional sessions judge? up to 1 lakh, up to 10,000, any fine authorized by law, A and B. The correct answer is any fine authorized by law. So the sessions judge or the additional sessions judge can impose any fine which is authorized by law. As per section 29 of the Code of Criminal Procedure, a sessions judge or additional sessions judge may impose any fine authorized by law. There is no fixed upper limit specified in the code for fines by these courts. The amount of fine depends on statutory provisions, that is, the law, or under the relevant provisions of Indian Penal Code or other criminal laws. The nature and seriousness of the offence should be kept in mind when fixing fine limits. This ensures flexibility and adherence to the maximum fine prescribed by law. What sentence can be passed by an assistant sessions judge? So don't confuse it with additional sessions judge. It is assistant sessions judge. So he can pass a sentence up to 10 years. He cannot pass a sentence exceeding 10 years. Assistant 10 years. Assistant 10 years. As per section 28 subsection 2 of the Code of Criminal Procedure, an assistant session judge may pass any sentence authorized by law except death sentence, imprisonment for life, and the maximum sentence that an assistant sessions judge can award is 10 years of imprisonment for an offence. He cannot give an imprisonment of more than 10 years. Next one. What sentence can be passed by a chief judicial magistrate? So now we saw assistant sessions judge can imprison a person for not more than 10 years, and a chief judicial magistrate can imprison a person for not more than 7 years. Section 29 subsection 1 of the Code of Criminal Procedure states that a chief judicial magistrate may pass any sentence authorized by law except death sentence and imprisonment for life, imprisonment exceeding 7 years. The CJM can impose fine as authorized by law and imprisonment up to 7 years. So these are the two punishments that a chief judicial magistrate can impose on the accused when he is a convict. Again, to recall it, assistant session judge can pass an imprisonment not more than 10 years, and the chief judicial magistrate can pass imprisonment not more than 7 years. 28. What sentence can be passed by the judicial magistrate of first class? So we saw sessions, assistant session judge, we saw chief judicial magistrate. Now we are saying judicial magistrate of first class. Option A and B are right. So not exceeding 3 years. So the judicial magistrate of first class can pass or impose punishments not exceeding 3 years. So he can impose punishments up to 3 years of imprisonment and fine not exceeding 10,000 rupees. He can impose a fine of only 10,000 rupees. He cannot impose punishments of fine of exorbitant amounts. A and B are right. As per section 29 subsection 2 of the Code of Criminal Procedure, a judicial magistrate of first class may pass any sentence authorized by law except death sentence, imprisonment for life, imprisonment for a term exceeding 3 years, and fine exceeding 10,000 rupees. So therefore, the maximum powers of the first class magistrate, that is chief judicial magistrate of first class, is imprisonment not more than 3 years, fine not more than 10,000 rupees. Next question on your screen. What sentence can be passed by the court of magistrate of second class? So he may pass sentence of imprisonment not exceeding 1 year. So the judicial magistrate of first class can pass punishments of not more than 3 years. So he can pass up to 3 years, and the magistrate of second class can pass imprisonment or impose imprisonment not exceeding 1 year. So he can imprison a person for at least 1 year. Next one. Section 29, subsection 3 of the Code of Criminal Procedure states that a judicial magistrate of second class may pass any sentence authorized by law except death sentence, imprisonment for life, imprisonment exceeding 1 year, fine exceeding 5,000 rupees. Therefore, the maximum powers of the second class magistrates are imprisonment not exceeding 1 year and fine not exceeding 5,000 rupees. So, the first class magistrate can impose a fine of 10,000 rupees and the magistrate of second class can impose a fine of 5,000 rupees and not more than. So, what fine can be imposed by the court of judicial magistrate of first class? Not exceeding 10,000 rupees. And what fine can the judicial magistrate of second class impose? A fine not exceeding 5,000 rupees. Next one. What fine can be imposed by the court of magistrate of second class? We already saw this, not exceeding 5,000 rupees. Next one. Can a magistrate direct that all the punishments run concurrently? Yes, a magistrate can direct all the punishments which can run concurrently. As per section 28 subsection 4 of the Code of Criminal Procedure, when a person is convicted of 2 or more offences by the same court, the court may direct that the sentences shall run concurrently. Concurrently means at the same time. Punishments can run at the same time instead of consecutively. For example, a person has committed an offense of theft and an offense of criminal conspiracy. Okay? So the punishment of criminal conspiracy is different and the punishment for theft is different. And these two offenses are given punishment simultaneously only, right? So it is not necessary that he should first serve the imprisonment for theft, which is, for example, 7 years. And then he should serve the imprisonment for criminal conspiracy for another set of years. They can run concurrently. Both the punishments of 2 offenses or 2 or more offenses can run concurrently at the same time. Next one. Can the court of magistrate award imprisonment in default of payment of fine? Yes, the court of magistrate can award imprisonment in default of payment of fine. Section 30 of the Code of Criminal Procedure states that where a person fails to pay a fine, the court may, in addition to any other punishment, order that the person be imprisonment for a term equivalent to the fine or as prescribed by law. This is known as default imprisonment. Next. Can the court of magistrate award 4 years of imprisonment in default of payment of fine? If a person who is imposed a fine of some amount, can he be imprisoned for 4 years on default of payment? No, he cannot be imprisoned for 4 years on default of payment of fine. He cannot be awarded imprisonment in excess of the powers of the magistrate prescribed under section 29. Because it prescribes only 3 years. The magistrate of first class can imprison only for 3 years and the magistrate of second class can imprison only 1 year. He cannot imprison a person who did not pay a fine for more than 3 years. So 4 years rule is wrong. The chief judicial magistrate can imprisonment to a period of 7 years. Next one. Can the High Court withdraw any of the powers conferred by it on any officer subordinate to it? The answer is yes. The High Court can withdraw the powers conferred on it by any subordinate officer. As per section 35 of the Code of Criminal Procedure, the High Court may, from time to time, withdraw any powers conferred by it on any officer subordinate to it or direct any officer to exercise any powers in a particular case. So this provision actually gives the High Court full supervisory control over the subordinate officers, and the powers of withdrawal or direction can apply to judicial officers like magistrates of first class, second class, chief judicial magistrates, sessions judges, additional judicial magistrates or assistant judicial judges. So it applies to all judicial officers and administrative officers under the Criminal Procedural Code. So administrative officers include district magistrates and executive magistrates also. So this ensures effective administration of justice and uniform exercise of powers in the state. Can the superintendent of police exercise the powers of officer in charge of a police station? The answer is throughout the district to which he is appointed. So, if a superintendent of police is appointed to a particular district, he can exercise the powers of the circle inspector or the inspector in charge of a police station also. Next. So, this legal position is taken from section 36 of the Code of Criminal Procedure, where it states that a superintendent of police may exercise throughout the district to which he is appointed all the powers of an officer in charge of a police station under this code. This includes powers to register and investigate crimes, conduct searches and seizures, exercise powers of arrest, supervise subordinate officers. So, this provision ensures district level policing authority and centralized control over investigations. 37. Can the Director General and the Inspector General (IG) of police exercise the powers of officers in charge of a police station? Obviously, if the Superintendent of Police can exercise the powers which is conferred on an officer in charge of a police station, why not a DG or an IG? They also have the same powers. Section 36 of the Code of Criminal Procedure, the same section which the Superintendent of Police is empowered, states that the Director General of Police and the Inspector General of Police may exercise throughout the state all the powers of an officer in charge of a police station. The only difference is the Superintendent of Police may exercise it throughout the district in which he is appointed. The Director General or IG can exercise it throughout the state in which he is appointed. Next one. Every person is bound to assist a magistrate. When is he bound? Every person is bound to assist a magistrate, right? So every person is bound. When is he bound? When the magistrate reasonably demands aid in the prevention or suppression of a breach of peace, in prevention the escape of a person whom he is authorized to arrest, in the prevention of an injury attempted to be committed to any railway, canal, telegraph, or public property. So, in such cases, in all these cases, any person can be bound to assist the magistrate. So, section 41 of the Code of Criminal Procedure states that every person is bound to be the best of his ability to assist any magistrate or officer lawfully executing the provisions of this code. Why? To prevent or suppress a breach of peace, to prevent the escape of any person whom the offender is authorized to arrest, and in preventing the injury to any railway, canal, or telegraph or public property. Failure to assist on the request of the magistrate can lead to penal consequences under Code of Criminal Procedure. 39. Every person is bound to give information to the nearest magistrate or police officer when he knows of the commission of what? So, in case you know a commission of an offense or a commission of something, you need to go to the nearest magistrate and give information. You are bound to do so. Under what commissions, under what happening of an event, you are bound to give information is that when there is an offense against the state, there is a person who criminally conspires to act against the state or omit to do to act against the state, then you need to inform it to the nearest magistrate or police officer. One. Next, offense is against public tranquility. If there is an offense which is committed by a person which creates where there is no peace, where the public tranquility is not maintained, then you can go and give the information to the, you are bound to inform the nearest magistrate or police officer. Where offenses relating to adulteration of food and drugs, in case there is a medicine, drugs in the sense, it is not the drug which you consume as alcohol, it is the drug which can be available even in medical shops. So, in case there is an adulteration of drugs or an adulteration in the food, you are bound to inform the nearest magistrate or police officer. Do not ignore to inform them. If you ignore to inform, then you are part of the offense. Offenses affecting life. if someone attempts to kill someone, or if someone attempts to steal the property of someone, if someone attempts to or does any dacoity, then watching this, you should not move away. You are bound to give such information to the nearest magistrate or police officer when you know that the commission of an offense or an attempt to commit an offense has been made. All of the above are correct. Next one. When is a person bound to help in the execution of a warrant? So there is a warrant which is executed. Now you need to help the court in executing the warrant. You are bound to help. So when are you bound to help? Bound in the sense it is mandatory that you need to help the court in executing a warrant case. When are you bound? If the person to whom the warrant is directed is nearby and trying to execute the warrant. So, for example, a police officer is trying to arrest a person who is detained for a warrant case. Now, when attempting to arrest him, there is some problem over there, and the person who is trying to execute the order is not able to execute. You are standing nearby to the person who is executing such warrant of arrest. Now, you need to help that police officer or the person who is trying to arrest that person who is under the execution of a warrant case. You are bound to help. You cannot stand and watch a police officer struggling to arrest a person who has committed an offense which comes under a warrant case. Section 40 of the Code of Criminal Procedure states that every person is bound to assist any officer or person lawfully executing a warrant if such person is nearby and is trying to execute the warrant. So the duty is limited to assisting in the vicinity of the execution. There is no obligation to travel to another place to assist or help someone at a distant location. So this ensures practical support in enforcing the law without undue burden on citizens. So as a common concept, uh, the general public may think that in case we help the prosecution, we may get into some problems. See, we won't get into any problems. We are bound to, in fact, we are bound to help the police. So it is authorized that we can help. Who is proclaimed offender? Who is a proclaimed offender? So any person proclaimed an offender by the court or authority in any territory in India is a proclaimed offender. For example, if an offender is in the wanted list in any police station, if his photo has been stuck in the notice boards of a police station, then he is a proclaimed offender because he is proclaimed as an offender by the court. It is not that the police themselves attach the photo in the notice board. It is the court which directed him as a proclaimed offender. Then the police puts his photo on the notice board if he is wanted. Section 82 of the Code of Criminal Procedure states that a proclaimed offender means any person who is proclaimed as an offender by a court or other authority competent to do so under the provisions of this code in any territory in India. A person is proclaimed offender when he avoids appearance in court after summons or warrants are issued. Proclamation allows authorities to search, seize property, and declare the person as absconding. Absconding is known as fleeing away, not not coming to the court or acting according to the law when there is a warrant issued against. Next one. Any police officer may, without an order from a magistrate and without a warrant, arrest any person. So when does this happen? Any police officer may, without an order from the magistrate or without a warrant, arrest any person. So when he is declared as a proclaimed offender, as we saw in section 86, or if he is a deserter from any of the armed forces, or who has in his possession any implementation of housebreaking. In such cases, a police officer may, without an order of the magistrate and without a warrant, arrest him. Next one. A police officer may arrest in what cases? So option C is the correct answer. he can arrest a person who has committed a non-cognizable offense in his presence and refused to give his name and address. So in case you are arrested, in case in case someone has did a non-cognizable offense and the police officer asks for the name, inform your clients. In case you are advocates, inform your clients that do not tend to protect your name or address, because the police officer has an immediate action of arrest in case you do not do it. Only in cases where there is a cognizable case which is made, the police officer can arrest you. But in case you committed a non-cognizable offense and you try to not give your name or address, then he can arrest. Or if you give a false information which the police officer knows, then he can arrest. Next one. Section 41, subsection 1, subclause B of the Code of Criminal Procedure states that a police officer may arrest without warrant any person who commits a cognizable offense, a person who commits a non-cognizable offense in his presence and refuses to give his name and residence or gives false information. Police cannot arrest for a non-cognizable offense. Otherwise, they must record information and refer to the magistrate. Next one. What is the duty of a police officer after ascertaining the true name and address of the person who has committed a non-cognizable offense in the presence of the police officer and initially refused to give his name and address? So now you committed a non-cognizable offense, your client committed a non-cognizable offense, and the police officer asked for the name and address. Initially you refused it, but later you told the name and address. Now, when you refused it, the police officer would have arrested you, right? After the arrest, you give the name and address. Now, what is the duty of the police officer during this situation? Now, the police officer shall release such person on executing a bond with or without sureties. So, after arrest, you give the name and address. Now, the police officer can release you after you execute a bond with or without sureties. Usually, it is with sureties. Okay, the police does not exempt you without sureties in such cases, but it is a common practice that they ask for sureties, but it is not necessary that you need to execute a surety, but it is only upon the demand of the police and with respect to the offense you committed in front of the police. Section 41, subsection 1, clause B of CrPC states that police may arrest a person who commits a non-cognizable offense in presence if he refuses to give the true name and address. Subsection 2 clarifies that after ascertaining the true name and address, after the arrest, the police officer may release the person on executing a bond with or without sureties and then forward it to the producing before the magistrate if not required unless there is other legal reasons like cognizable offense which is committed or an ongoing investigation with respect to a cognizable offense. 45. What should a police officer do if the true name and address of a person arrested for a non-cognizable offense is not ascertained within 24 hours of arrest? He should be produced before the nearest magistrate having jurisdiction. Section 57 of the Code of Criminal Procedure states that the maximum detention without magistrate permission is 24 hours. After 24 hours, if the true name and the residence of the arrested person are still not ascertained, then the police officer must produce the person before the nearest magistrate having jurisdiction. So this ensures that a judicial oversight is there in ascertaining his name and address and why he committed the offense, and it also prevents the arbitrary detention by the police. Next, when can a private person arrest another person? So a private persons are also qualified to arrest another person under the authorization of the magistrate, right? When can a private person do so? If that other person is a proclaimed offender. If that other person is a proclaimed offender, a private person can arrest him. Or if any person commits a cognizable and non-bailable offense in his presence. For example, A is a person, B is a person. Now B commits a murder in front of A and it is cognizable, it is non-bailable. Then A can arrest him. Or if B is a proclaimed offender set by the court, then A can arrest him. he need not be a police officer. So section 43 of the Code of Criminal Procedure states that a private person may arrest any person who commits a cognizable offence in his presence, any proclaimed offender. Next, what is the duty of a private person after arresting an offender? Both A and B are the duties of a private person after arresting that offender. So a private person can arrest another person in case he is a proclaimed offender or he did a cognizable case offense or a non-bailable offense, right? So now what is the duty of the private person after arresting? He should, without unnecessary delay, he shall make over such person to the police officer. He shall take him to the police officer, or he should call the police and inform that he has arrested a person who is a proclaimed offender, or he did a cognizable offense or a non-bailable offense before me, and inform the police officer immediately. Without delay means immediately. In the absence of a police officer, the offender should be taken in custody to the nearest police station. So, in case the police officer is not immediately available near that locality, he should be taken in custody to the nearest police station. Both A and B are right. Option C says he should be produced before the magistrate. No, a private person cannot produce him directly before the magistrate. He can complain it to the magistrate, nearest police station or magistrate, but he cannot arrest himself and take him to the magistrate. He should take him to the nearby police station or inform the nearest police. As per section 43, subsection 2 of the Code of Criminal Procedure, a private person who arrests someone must, without unnecessary delay, hand over the person to the police officer. If no police officer is available, the person should be taken in custody to the nearest police station. If the private person cannot conduct investigation or trial, the responsibility is to hand over the offender to the proper authorities. If the private, for example, if the private person is a police himself, then he can conduct investigation or trial. If he cannot conduct investigation or trial, then the responsibility is to hand over the offender to the proper authorities. That is the police officer. 48. If a police officer feels that there is no sufficient reason to believe that a person has committed any offense, what should he do? He should be released at once. For example, you are a private person and you think someone as a proclaimed offender. You think him to be a proclaimed offender by just seeing him, and you arrest him and take him to the police station. And the police feels that there is no sufficient reason or there is nothing that he is a proclaimed offender. Then the police shall at once release him. He should not be detained for any cause. Section 41, subsection 1, clause A, and section 41, subsection 2 of CrPC states that arrest without warrant is only justified when the police have reasons to believe that a person has committed a cognizable offense. It is also in cases where the police officer himself sees an offense being committed. Okay. If upon assessment the police finds no sufficient reason to believe that an offense has been committed, the person cannot be detained. He must be released immediately. Next one. Can a magistrate arrest any person? The answer is the magistrate may arrest any person who commits any offense in his presence and within the local jurisdiction. In case a magistrate goes to a mall and in the mall there is an offense committed by some person, the magistrate himself can arrest that person and detain. As per section 41, subsection 1, clause A of CrPC and general powers of a magistrate under CrPC, the magistrate can exercise powers of arrest for offences committed in his presence. The power is limited to the magistrate's local jurisdiction. He cannot go and arrest in someone else's jurisdiction. For example, a magistrate who is appointed in the district of Dindakal cannot go and arrest a person who is in the district of Madurai, even if it is in his own presence. But he can inform the police immediately. For offences not in his presence, the magistrate generally cannot personally arrest, but can direct the police to do so. This ensures the magistrate's authority is exercised within the legal limits and prevents arbitrary actions by the magistrate. Last question of this session. Can a magistrate direct any other person to arrest? The magistrate may direct any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. Section 44 says what is an arrest by magistrate, where when any offence is committed in the presence of a magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. Any magistrate may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in circumstances to issue a warrant. So with this, this session ends, and here's the homework question for you. In consent of a central government required for arresting a member of the armed forces, option A, in such member, if such member has committed the offence in discharge of his official duty, if such person has committed the offence without discharge of his official duty, if such person has committed non-cognizable offence, none of the above. I want you all to mention the answer in the comment section, and I hope this session would be fruitful for you. And to follow more on our channel, I want you all to subscribe to my channel and watch it. And please do share it to your friends and juniors so that it will be helpful for them as well. And we have also posted videos on how to do cross examination in our channel, and it will be around 100 and more videos on that as well. If you are an advocate who is practicing on criminal side, I want you to watch it. It will be very fruitful for you. So with that, I end part 16 from 751 to 800 questions. See you in the next interactive session, part 17. Stay tuned to our channel.